Please be seated. Court will be in session. First matter we have is People versus Robert Charles Duff, file number 2105081. Mr. Duff, please come forward. Mr. Duff, please state your full name.
Robert Charles Duff.
What is your mailing address?
225 Ewan Lake Road, P.O. Box 32. That's
What post office box?
32. That's Little Lake, Michigan, on Market County.
49833 is the zip.
I couldn't hear you.
49833 is the zip.
And let's restate the post office box again.
32.
Little Lake.
Correct.
All right. What is your date of birth?
128, 1990.
Mr. Duff, this was set for arraignment on June 21st at 9 a.m. and you failed to appear for arraignment. Also, the address you gave us was incorrect. We had a couple of different addresses, one in Little Lake at 235 Bowden Lake, and then 632 Brookfield Drive in Marquette. Both those addresses were incorrect. But apparently there was some communication with you letting you know that you had court at 9 a.m. on the 21st. Why did you not appear?
Yes, sir. I do recall calling. I do recall talking to the lady. You know, I really thought she said it was 11 o'clock Zoom meeting.
Well, we had the Zoom on at 11 o'clock too, and
I
nobody.
called, and she said that no, your court was at 9. It was too late. She said she was going to try to talk to you. There was no way that she could squeeze me back in there. I couldn't get the Zoom to work. It's all my fault. This error.
Okay, well, I'm glad that you came to that conclusion because that's absolutely correct. It's your responsibility to know what time you need to go to court. And it's your responsibility to make contact with the court. Now we're past Zoom now. For certain circumstances, you can get permission to appear by Zoom, but you have to get permission to do that because what we're finding is people think they can just appear by Zoom, and at 3 minutes to the time for court, they try it and it doesn't work because their bandwidth or their device is insufficient. And we have a number of cases on the docket, so we just don't have the time to dedicate to trying to work out someone's software glitches. And so when you're summoned to court, as you may know, you have to be here on that time to avoid a bench warrant for arrest for contempt of court. Now, the court issued that, but under the circumstances, I'll dismiss the contempt bench warrant and we'll just proceed on the original charge today. But please make every reasonable attempt to be here when we have court. And usually you can make arrangements. We don't send a letter saying you have to be in court the next morning. We give you a week or two to get ready to make sure that you have arrangements. You can silence your device. I'll give you a minute to do that. All right. The state has filed a complaint against you that charges that on or about May 21st, 2021 in Schoolcraft County, Michigan and Seney Township, you did operate a vehicle upon a highway, M28 near M77, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood. It's also noticed that you were previously convicted of operating while impaired on or about December 27th, 2007 in the 92nd District Court. Therefore, upon conviction, you are subject to an enhanced sentence. This is a misdemeanor known as operating while intoxicated, second offense. It carries a maximum punishment of a fine of no less than $200 up to $1,000. Court costs and fees could more than double that. No less than 5 days in jail, up to 1 year in the county jail, or 30 to 90 days community service, or both. You also may be ordered to participate in rehabilitative programs, pay for the cost of prosecution, reimburse the government for emergency response and expenses for your prosecution. Vehicle immobilization is mandatory for not less than 90 days nor more than 180 days, and the Secretary of State could take action against your driver's license or your ability to obtain one based on your master driving record. It likely would be revoked. Do you understand the charge and the possible maximum penalties? To this charge, you have a number of rights. Did you receive the advice of rights form today? Did you read and understand all the rights listed on that form? And did you sign and date the form?
No.
Please sign and date it. That's all we need. And today's date is June 23rd. Thank you. To this charge, you have the right to plead guilty, not guilty, or stand mute and say nothing. If you plead not guilty or stand mute, I'll set the matter for further proceedings. If you plead guilty, you'll be giving up all the rights listed on the advice of rights form, including the right to have an attorney at public expense if you could not afford one. And Ms. Denholm is available here today for you to consult with if you wish. But you'll be giving up that right if you plead guilty. Also, if you're on probation or parole for any offense, a guilty plea could be a violation of that probation or parole. Ms. Denholm, do you know how Mr. Duff wishes to proceed?
Your Honor, I've had some conversation with Prosecutor Noble about this case, and he's going to offer while intoxicated first offense. Mr. Duff would agree to plead guilty to that.
Okay, so there's a plea agreement that states that in exchange for a plea of guilty to OWI first offense, the people would accept that disposition in this case. Is that correct?
Yes.
Are there any other civil infractions, or was there a PPT taken as well? There's, okay. All right. Okay, thank you. Do you understand by accepting the plea agreement and pleading guilty to operating while intoxicated first offense that you'll be giving up all the rights listed on the advice of rights form?
Sure.
And is that, are you pleading guilty to operating while intoxicated first offense and accepting the plea agreement?
Yes, sir.
Has anybody other than the plea agreement promised you anything in exchange to get you to plead guilty?
Right.
Has anyone threatened or forced you to get you to plead guilty? Are you pleading guilty freely and voluntarily and of your own choice?
Yes, sir.
Were you operating a vehicle on M28 near M77 in Seney Township of Schoolcraft County back on May 21st of this year?
Sure.
Whose vehicle was it?
Gene Atkinson's.
Pardon me?
Gene Atkinson's.
Okay, did you have permission to use the vehicle at the time? And what type of vehicle was it?
2014 Toyota Tundra truck.
Do you know why the police pulled your vehicle over when you were driving?
Speeding.
Did you consume any alcoholic beverages before you went driving?
Yes, sir.
How much and what?
He's 5 mixed drinks, 6 mixed drinks.
That included alcohol?
Yes, sir.
And then as a result of your arrest, did you undergo any blood alcohol testing?
Yes, I did, Your Honor.
Did you find out what the results were? Okay. Do you know Ms. Denholm?
I don't.
But they did arrest you because it was over the legal limit? Oftentimes on the citation, they will cite the PVT results. There is a civil infraction for speeding 107 in a 65 zone. Is that correct?
Yes, Your Honor.
And I'm presuming that people aren't proceeding with a driving suspended charge?
Apparently not.
That's on the ticket?
Yes, it's not charged.
Okay. I don't see the PBT results on the citation, but as long as there's a stipulation that it was over the legal limit of 0.10, excuse me, over 0.08,
Okay.
the court will, are you satisfied with the record with that information?
I am.
Well, the court is satisfied that your guilty plea was knowingly, voluntarily, and understandably made, that there is an accurate factual basis to warrant a finding of guilty because on the date and location alleged in the complaint, you did consume a substantial quantity of alcoholic beverages, that you agree your blood alcohol was over the legal limit, therefore a judgment of guilty to operating while intoxicated will be rendered. You'll need to take care of the civil infraction in the front court office here today before you leave. Are you admitting responsibility to that? Okay. The fines and costs are posted for the amount of miles per hour that you've driven over the speed limit. The speed limit in that location was what?
65.
65? All right. So how many miles over it'll be calculated, and you'll need to take care of that today. Have you had a substance abuse assessment recently?
I have one set up for the 2nd. in
For-
Marquette County.
July 2nd in Marquette County? Okay. We'll set the matter for sentencing. We'll mail you a notice at Post Office Box 32, Little Lake, Michigan, 49833. Make sure you check your post office box regularly, because if you fail to appear, the court could issue a bench warrant for your arrest, and that could be really inconvenient, and it would result in possible incarceration. Also, when you come to court for sentencing, be prepared, because there may be an incarceration sentence. And I'm just being fair with you by telling you in advance you need to make arrangements for that. The court will look at your entire record, but also the court will look at everything, including any changes you've made in your life for the better. And that includes employment, it includes whatever efforts you're making to avoid substances altogether, etc. Your attorney can give you more information on that. Okay? Okay. All right. Bond conditions will continue. Have you been following them? So if we test you today, you'll test clean. Are you being tested now by any other agency?
I have it with my full officer regularly.
With the parole office? Okay. All right. Okay, I'll continue your bond. Thank you. You're free to go.
Short recess if we might, Your Honor.
Court's in recess for a moment.
All rise.
Please be seated. Next matter is Jonathan Keith Stevenson. This is file number 2106098. Please state your full name, sir.
Jonathan Keith Stevenson.
Is your mailing address still 1365 North Kendall Road, Manistee?
No, it's not.
What is your current address? Mailing address.
496 County Road, 441, apartment 2. But I'm actually selling it and closing on the house next week. I'll be out of there by July 7th. And I don't know the next address off the top of my head.
So if we mail you a notice to appear, you will get it at least for the next 2 weeks at 496 County Road, 441, apartment 2, Manistee.
Yes, sir.
Okay, thank you. And again, please keep the court advised as soon as you change your address. It's your responsibility to do that because our system is computerized and we mail all our notices to the address that people give us. Okay?
Yes, sir.
Can you do that?
Yeah, I just come to the.
You can just call the court or come in and give them your new address as soon as it's changed. What is your date of birth, sir?
12/29/1988.
Thank you. Mr. Stevenson, and this is file 2106098. The state has filed a complaint against you that charges that on or about June 16, 2021 in the city of Manistee, Schoolcraft County, Michigan. In count 1, you did operate a motor vehicle upon a highway, South Cedar Street and Walnut Street, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood contrary to law. That is a misdemeanor known as operating while intoxicated. It carries a maximum penalty, if convicted, of up to 93 days in the county jail, a fine of no less than $100 up to $500. Up to 360 hours of community service could be ordered. You may be ordered to participate in rehabilitative programs, pay for the cost of prosecution, and reimburse the government for emergency response and expenses for your prosecution. Also, the Secretary of State could take action against your driver's license based on your driving record. Do you understand the charge and the possible maximum penalties?
Yes, sir.
Count 2 states on the same date and location, you did operate a motor vehicle upon South Cedar Street and Walnut Street, a highway, while your operator's license was suspended or revoked as prohibited by law. In short, you are charged with operating a vehicle while your driver's license was suspended or revoked by the Secretary of State. To that charge, that is a misdemeanor that carries up to 93 days in the county jail, a fine of up to $500, and possible vehicle immobilization. Also, the Secretary of State could take action against your driver's license based on your driving record if you are convicted of that charge. Do you understand that charge and the possible maximum penalties?
Yes, sir, but I don't remember getting this driving not suspended. I did have a valid license. I'm not sure.
Okay. Again, I'm not asking if you agree or understand why you're charged, but if you understand that you are charged with it and what the penalties are.
Yes.
Okay, you do.
Yes.
Okay, thank you. To these charges, you also have a number of rights. Did you receive the advice of rights form?
I did.
Did you read and understand all the rights listed on that form?
Yeah, I did.
Okay. And did you sign and date the form?
I did.
To these charges, you have the right to plead guilty, not guilty, or stand mute and say nothing at all. If you plead not guilty or stand mute, I'll set the matter for further proceedings. If you plead guilty, you'll be giving up all the rights listed on the advice of rights form, and there will not be a trial of any kind. You'll also be giving up the right to have a lawyer to represent you at public expense if you could not afford one, if you plead guilty. And Ms. Denholm is here available to speak with you about the case if you have questions. If you're on probation or parole for any offense, a guilty plea could be a violation of the probation or parole. Ms. Denholm, do you know how Mr. Stevenson wishes to proceed at this time?
Your Honor, I've also spoken to Mr. Noble about this case before court started today. He's operating while impaired as a complete resolution of this case. So that would be a dismissal of count 2 as well.
And is that plea agreement going to be accepted?
Yes, it is.
Okay. Do you understand the plea agreement that in exchange for a plea of guilty to the reduced charge of operating while impaired, the prosecutor would dismiss the operating while intoxicated and the operating while suspended? Do you understand that? All right. On behalf of Mr. Stevenson, what plea then does he wish to offer to operating while impaired?
And then it's a plea of guilty pursuant to the plea agreement.
Is that guilty plea entered with your consent?
Yes.
And do you understand that you're giving up the rights listed on the advice of rights form by pleading guilty?
Yes.
Other than the plea agreement, has anybody promised you anything in exchange to get you to plead guilty? Has anyone threatened or forced you to get you to plead guilty?
No.
Are you pleading guilty freely and voluntarily and of your own choice?
Yes.
Were you operating a vehicle on South Cedar Street and Walnut Street here in the city of Manistee, Schoolcraft County, Michigan on June 16th when this happened?
Yes.
What type of vehicle were you operating?
2013 Ford Fusion.
Was this your vehicle?
Yes.
And do you know why the police pulled your vehicle over?
Then come to a complete stop at a stop sign.
Did you have any alcoholic beverages to drink before you went driving?
Yes.
How much and what?
5 beers and 2 shots.
2 shots of what?
Dr. McGillicuddy's.
Okay, and that's a liquor.
Yes.
And the beer was the kind with alcohol in
Yes,
it?
sir.
Thank you. As a result of your arrest, did you take any kind of a chemical test to determine the blood alcohol level in your blood?
Yes.
Do you remember what the results were?
0.12.
Okay. Are you satisfied with the record, Ms. Denholm?
I am.
The court is satisfied that your blood alcohol, that your guilty plea was knowingly, voluntarily, and understandably made, and that there is an accurate factual basis that warrants a finding of guilty because on the date and location alleged in the complaint, you did operate a motor vehicle with an unlawful bodily alcohol content, and that after consuming a substantial amount of alcohol, therefore a judgment of guilty will be rendered to operating while impaired. We'll set the matter for sentencing.
And you already actually have the substance
Oh.
abuse assessment in the file.
We do. I dislocated it. You ready to proceed to sentencing? Pardon me?
Yes.
Okay. Is there anything you wish to state on behalf of your client before sentencing?
Yeah, Mr. Stevenson is a young man who generally makes very good choices and unfortunately made a bad choice in the state. He's a well-respected member of the community. He works for Louisiana Pacific and has done for 6 years. He has a young child at home. I would know that he, because of this arrest, he does have 1 day of jail credit. Mr. Stevenson got right on getting this taken care of, as you can see by the fact that just within a few days, he was able to get the substance abuse assessment done. I think should get credit for being able to take care of business in that efficient fashion. This, the loss of his driver's license or the suspension of his driver's license here is going to be some difficulty to him in regards to his employment, but I think he's already made those arrangements to take care of that matter and will be difficult to the court. I don't know that that the court needs to impose anything more than this.
Okay, thank you. Mr. Noble, anything by the people?
Your Honor, there's the standard fees from us, $250 for cost of prosecution and $50 for the blood draw. The thing I'd say about John, and I know John since he was a young teenager, probably. He's a good person by and large. Never really had any trouble with John, but this is a poor choice. And when we drive intoxicated, and I say we, I mean Mr. Stevenson in this case. If you drive intoxicated, you put yourself at risk, of course, and of course you put all the other users of the highway system at risk. And Mr. Stevenson knows that. I know he knows it. And the dangers of operating under the influence. We won't get into all of that, but we know it's dangerous. And I hope that Mr. Stevenson makes better choices in the future because, you know, these are, it's just a, really no other way of putting it other than a really poor choice by Mr. Stevenson on this day.
What is the status of his driver's license? Because he seems to think he had one. And
I'd have to do research, call Secretary of State and everything else. My understanding was it was suspended, but if that's not accurate, we can do some follow-up. We can check with Secretary of State, we can run it and get a correct status. But I am dismissing the
right.
WLS, but we should find that out. In fact, I'll as soon as we get done with court here, we'll do a little poking around on that, try to find out the exact status. An impaired, of course, will restrict his license. Let's assume for a minute that it's valid. It will usually, I don't speak for the Secretary of State, but usually an impaired restricts it for 90 days, I believe, for work, school, and court and medical appointments only. So there's no driving for personal use. So you'll need to be cognizant of that. What if it's suspended? We'll double check and figure that out for him. Because you don't want to see a person get in trouble for something that if they can figure out a way to rectify that situation easily.
Okay, great. Anything further, Ms. Denholm?
No, Your Honor.
Okay, do you have anything you want to tell me before I pronounce sentence, Mr. Stevenson?
No, just on the suspended license. That's kind of my biggest concern here right now is retaining or getting a restricted license as soon as possible. I'm about 99% sure I had a valid license. I have no reason. I mean, it has been suspended in the past, and I had a driving on suspended in the past, but I've taken care of all fees. I went and got my license back, and I've had no issues. So.
Do you have a valid driver's license with
I
you
did.
today?
I mean, they took it that night, and then they actually gave me a piece of paper saying, this is your license to drive until court. So
Okay.
they
All
didn't
right.
say anything when they arrested me about suspended license. It was,
You'll need to check with the Secretary of State. I know that's not easy right now for some reason. Okay. All right, because I can't advise you on whether you have a license or not. Only they can tell you. Is there anything else you want to say?
I'm just not sure how to go about that.
Okay,
That's my biggest issue. I have to get to work, so.
sure. All right, well, fashion a sentence to allow you to do that. Did you serve 1 day in jail?
I did.
Okay. All right. Drinking and driving is very dangerous behavior. Everybody knows that, but it still happens because when a person drinks alcohol, their ability to make good choices is influenced by that. That's the nature of alcohol as a substance. So it's important that if you are consuming alcohol at any time that you think about that before you start consuming, that you're going to make good decisions and you're going to take 10 seconds and, figure out, is this the right thing for me to do? Nobody drunk ever does that, but it may help to do it before you start drinking. You're operating a machine that goes down the road. It weighs thousands of pounds. Even at 20 to 30 miles an hour, that's a lethal closing speed with an oncoming vehicle, even with airbags, because what happens is two objects collide, physics takes over, and the organs inside your body tear away from their moorings, so to speak. even if you aren't otherwise injured because of the airbag safety. So that can cause serious injury or death. Every 50 minutes, someone is killed in a drinking and driving related accident in the United States. That's more than one an hour on average. So it's really important, and that's why the penalties are what they are. But I'll take into consideration your good character in the community. It'll be the sentence and judgment of the court. You pay fines and costs of $1,500. You serve 1 day in jail. 1 day in jail with credit for 1 served. And 63 days will be suspended on condition you pay the fines, costs, and fees. There's $250 prosecution costs, $100 police fee for the cost of arrest, and $50 for the blood draw. And I'm required by law to assess $125 for justice fees in every case. I'll give you 180 days to pay that, and then complete your alcohol highway safety education. Any questions? This will be put in writing and you'll get a copy of it. Do you think you can pay this within 180 days? All right, good. We'll mail you a copy to your address you've given us here today. But if you change your address, notify the court. Any questions? You'll need to make an appointment to pick up your probation or judgment order. I know you're not used to this, so you look a little bit confused, but maybe what we'll do is we'll just do the judgment and mail it to you, okay? And then you won't have to come in. All right? Anything further, Ms. Denholm?
No, thank you.
The amounts will be totaled up too, so you'll know exactly what you need to pay. Okay, any other questions? All right, you're free to go, sir. Thank you.
No, that's just for you. Those are both for you.
The next matters are for 10 a.m. Anyone here early for court? They want to proceed?
Mr. Zeller is.
Pardon me?
Mr. Christopher Zeller is on your calendar.
Okay. We'll have to change the address in the system to the post office box. Thank you. All right. The next matter is People versus Christopher Lawrence Zeller. This is file number 2106096. Please state your full name, sir.
Christopher Lawrence Zeller.
Is your mailing address 213 Ackley Road, Germfast?
No, it is 660
660
Corbridge Road, Corbridge, CORBRIDGE Road, Gulliver.
Is that 660 N?
Yeah, well, it's, 660 and I guess.
Gulliver, Michigan.
Yep.
The zip code there.
49840.
Thank you. And what is your date of birth, sir?
6/9/1995.
Mr. Zeller, the complaint charges that on or about June 9, 2021 in Doyle Township of Schoolcraft County, Michigan, you did operate a motor vehicle on County Road 432 in the Sunoco gas station area, a place open to the general public or generally accessible to motor vehicles, while your operator's license was suspended or revoked as prohibited by law. That is a misdemeanor. It carries up to 93 days in the county jail, a fine of up to $500. Do you understand the charge and the possible maximum penalties?
Yes, Your Honor.
Also, the Secretary of State could take further action against your driver's license based on your driving record. To this charge, you also have a number of rights. Did you receive the advice of rights form?
Yes, Your Honor.
Did you read and understand all of the rights listed on that form?
Yes, Your Honor.
And did you sign and date it?
Yes, Your Honor.
Thank you. We'll take that for the court record. To this charge, you have the right to plead guilty, not guilty, or stand mute and say nothing at all. If you plead not guilty and stand mute, I'll set the matter for further proceedings and a trial. If you plead guilty, you'll be giving up all the rights listed on the advice of rights form, and there will not be a trial of any kind. If you are on probation or parole for any offense, a guilty plea could be a violation of that probation or parole. Ms. Denholm, do you know how Mr. Zeller wishes to proceed?
Actually, I don't.
Do you know how you want to proceed?
Tim said he has to speak to
Hang
someone.
on a second.
Your Honor, before we proceed, I need to speak with the person that was struck by the automobile in this case and then for Mr. Zeller of that.
Okay.
And,
Do you want to?
I'll try to track her down in the next few
Okay,
days.
so you,
We're gonna have to set this for pre-trial. If we can do that
all
in
right.
July, I should have an answer.
Do you want a court-appointed attorney on this while it's reviewed?
No, Your Honor.
Are you sure? Because
Yes.
we'll give you one if you want one and you cannot afford one.
I do not qualify for that.
Okay. Are you going to hire an attorney?
No, Your Honor.
Well, you have the right to represent yourself, but I want you to understand clearly you have a right to have an attorney represent you. Do you understand that?
Yes, Your Honor.
Okay, and if you decide you want to do that, you need to take care of that as soon as possible.
Yes, Your Honor.
All right, at this time, because of the way the prosecutor has presented the case, from their standpoint, I'm going to enter a not guilty plea on your behalf at this time, and we'll set the matter for further proceedings. Of course, you always also have the right to change that plea to a guilty plea as well. If you change your mailing address, notify the court immediately because we'll be mailing the notice for your next court appearance to 660 N Corbridge Road, Gulliver, Michigan. All right, any questions?
No.
Okay. You're free to go at this time. Court will be in recess till 10 a.m. Okay, this is file number 2104070, People versus Justin Matthew Paquin. This matter has been set for pretrial today, but it's my understanding there's going to be a resolution of this matter. Mr. Noble, as the court has received an amended complaint changing the charge to disorderly person.
Yes, to drunken disorderly, Your Honor. That's a 90-day misdemeanor. There's also an agreement that if this is abstractable, the Secretary of State, which by all of our information it is not, that the defendant could withdraw his plea at that time. But we don't believe that it is. Neither your staff nor I believe that.
Well, it's not, certainly not a traffic charge.
It is,
so.
and that's why we believe it's not.
I think it only goes to the Secretary of State if it's a minor involved.
Okay.
That would make sense too, because then there would be alcohol with minor.
Right.
Your Honor, I'm going to step out and meet with Mrs. Denholm in the next case, since I believe this case is resolved.
Okay, do you have any other recommendations?
No, this one's pretty straightforward, Your Honor.
Okay, great. Please state your full name, sir.
Justin Matthew Bachman.
Mr. Paquin, is your mailing address still 210 North 2nd Street, Madison?
No, sir.
What is your mailing address?
P.O. Box 241, Manistee, Michigan, 498.
Thank you. And what is your date of birth?
12/4/86.
The plea agreement, as stated today, is that in exchange for a plea of guilty to disorderly person, the people would accept that in disposition of this matter and not proceed on the refusal of PBT on a commercial vehicle. Do you understand the plea agreement?
Yes, sir.
Okay.
Judge, the state has also agreed that they were thinking about possibly bringing OWI charges. They've agreed not to proceed with that.
Okay. Thank you for that clarification. Did you receive the advice of rights form today, Mr.
Yes,
Paquin?
sir.
Did you read and understand all the rights listed on that form?
Yes, sir.
Do you understand by accepting the plea agreement and pleading guilty to disorderly person that you'll be giving up all the rights listed on the advice of rights form and there will not be a trial of any kind?
Yes, sir.
On behalf of your client, Mr. Lemire, what plea does he wish to offer to disorderly person as charged in the amended complaint?
Guilty, we're hoping he'll be able to give a guilty plea, Judge. He was intoxicated at the time.
Okay. Is that guilty plea entered with your consent?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in exchange to get you to plead guilty? Has anyone threatened or forced you to get you to plead guilty? Are you pleading guilty freely and voluntarily and of your own choice?
Yes.
Tell me what happened at 617 West Lakeshore Drive near the Comfort Inn on May 1st here in the city of Manistee when this happened that makes you guilty of this offense.
I was outside listening to music, probably too loud, and somebody made a complaint. And that's what.
Were you intoxicated at the time? All right. And so you acted in a manner that caused a public disturbance. You agree to that?
Yes, sir.
And how did you become intoxicated?
I'd been drinking earlier.
Okay. All right. What did you drink?
Just beer.
A lot of beer?
Not too much. I wasn't extremely intoxicated. I was pretty coherent. I thought I was, but I
Okay.
definitely was
Intoxicated. Okay. Are you satisfied with the record?
Yes, Your Honor.
The court is satisfied that your guilty plea was knowingly, voluntarily, and understandably made, that there is an accurate factual basis to warrant a finding of guilty because on the date and location alleged in the complaint, you were in a public place, that you were acting in a manner that caused a public disturbance by playing loud music, and that you were intoxicated. Therefore, a judgment of guilty will be rendered. You wish to proceed to sentencing?
Yes,
Anything you wish to say at this time?
I'm hoping that the court will just consider costs and fines in the matter. My client is generally a responsible member of the community here in Schoolcraft County. He is a hard worker. He has been with the is it construction and laborers,
It's IBW.
IBW, for an extended period of time. He has been, during the course of these proceedings, employed. At one point, you let him go to, I believe it was New York.
I did, yes.
And how is that job going?
It's going well.
Okay, so, and then he can address the court as to what he's up to at the present time with regards to his employment and his personal life.
All right, thank you, sir. Did you serve any jail time? Okay. Anything you wish to say before I pronounce sentence?
Right now I'm taking on new responsibilities, new job, like different, like different kinds of things that we're doing within our company. Like we're taking on new things and I'm part of it, so.
You're being trained to address new procedures.
Yeah. So, I mean, other than that, everything's really good. Just
All right.
every day, go to work, wake up, do it all over again.
Where is that?
Albany, New York.
Okay. All right. The court will assess fines and costs of $350 or 35 days. There are state justice fees of $125 I'm required by law to assess. For the total is $475 or 35 days. Can you pay that within?
I can pay today.
Okay. All right. We'll have you pay it today and you can be on your way. Good luck.
I appreciate it.
Thank you, Judge.
Okay, thank you. Just go across the hall. Mr. Lemire, I'll give you the file and maybe the staff can work on that judgment. Maybe Mary can type it up. Okay.
Have a good day.
Thank you. You too. Next matter is People of the State of Michigan versus Nathan Dillon. Mr. Dillon here.
Mr. Dillon is here. And I know Mr. Carmack tried to reach out to me. I've been bouncing back and forth between here, back up to my office, court suite, trying to keep things on. So I apologize, Mr. Carmack, for not getting back with you.
Not a
Okay.
problem. Mr. Noble, could we, and Judge, could we have 2 minutes to discuss the case? Because I think we're very close to a resolution. Before we start.
Yes, I'll pass on this one and I'll go to the next one. I'll allow you to
All right,
discuss the matter.
If we want to move to the Mason one, Your Honor.
Well, Cantrell, is that going?
No,
Okay, so,
I just signed the paperwork.
all right, so you're doing a prosecutor diversion and that's file 2105082. So you're
No,
dismissing that
it's a
matter?
dismissal, yes.
Okay,
If you want to do the Mason one, Your Honor, we have a plea agreement. Ms. Mason will be pleading to it.
all right, I'll handle that next.
Thank you. And I'm going to call you, Mr. Carmack, right now.
Thank you.
Okay, thank you. Next matter is People versus Heather Marie Mason, file 2105078. The original charge being operating while intoxicated. That matter is set for pretrial, but it's my understanding there's a plea agreement in this matter.
That's correct, Your Honor. In exchange for my client's plea of guilty to reduce count of operating while impaired, the prosecutor will amend the complaint.
Please state your full name, ma'am.
Heather Marie Mason.
Is your mailing address 133 4th Street? Is it North 4th?
North 4th Street.
Okay. Manistee?
Correct.
Thank you. And what is your date of birth, ma'am?
4/10/76.
Thank you. You've heard the plea agreement that in exchange for a plea of guilty to the reduced charge of operating while impaired, the prosecutor would accept that disposition of this case. Is that also your understanding of the plea agreement? Were there any other charges on the ticket, the original ticket?
No, Your Honor.
Okay.
Let me just double check that though.
Sometimes there's speeding or PBT refusal, and I just want to make sure that's not part of.
No, Your Honor, there was just
Yes.
a warning for defective equipment.
Okay, all right. Did you receive the advice of rights form?
I did.
Okay, and did you read and understand all the rights listed on that form?
I did.
And did you sign and date it?
Yes, I did.
Do you understand by pleading guilty to operating while impaired that you'll be giving up all the rights listed on the advice of rights form and there will not be a trial of any kind? On behalf of your client, Ms. McGregor, what plea does she wish to offer to operating while impaired?
Guilty, Your Honor.
Is that guilty plea entered with your consent?
Yes, it is.
Other than the plea agreement, as stated here today on the record, has anyone promised you anything in exchange to get you to plead guilty?
No.
Has anyone threatened or forced you to get you to plead guilty? Are you pleading guilty freely and voluntarily and of your own choice?
Yes.
Were you operating a motor vehicle in Thompson Township on May 15th of this year when this happened?
Yes, I was.
What type of vehicle were you operating?
I was driving my car, a 2010 Equinox.
And do you know why the police pulled your vehicle over?
Yes, because I had a headlight out.
Did you consume any alcoholic beverages before you went driving?
Yes.
How much and what?
I had a couple of
White Claws, that's an alcoholic seltzer drink?
Yes, it is.
Okay. And as a result of your arrest, did you take any kind of chemical test to determine the level of alcohol in your
Yes, I
blood?
did.
Did you find out what the results were?
So, Your Honor, the labs have not come back, but Ms. Mason would like to just be done with this matter today. So we're just gonna go with the PBT on that. Her PBT came back at 0.107. It's my understanding that the prosecutor would be agreeable if the labs come back and they're not within the requisite limit, that he would be agreeable to allowing Ms. Mason to withdraw her plea.
Okay. And the court would grant that if that happened. Are you satisfied with the record?
I am, Your Honor.
The court is satisfied that your guilty plea was knowingly, voluntarily, and understandably made, and that there is an accurate factual basis that warrants a finding of guilty because on the date and location alleged in the complaint, you did operate a motor vehicle, that you consumed alcoholic beverages, and that your blood alcohol was over the legal limit. Therefore, a judgment of guilty will be rendered. Under Michigan law, there is required to be an assessment. And I believe that was done, right?
That is correct. We would like to go into sentencing today, Your Honor.
Okay, they're not recommending any further treatment or education, but I would suggest alcohol highway safety education program. That is generally what is the minimum that is. But I'll take argument if there's any reason why we shouldn't do that.
Yes, Your Honor. Well, Ms. Mason has no criminal history. She's a truth first. Her PBT bet was, pretty low in terms of, what the average is on these things, I think. I would ask today, I think that she comports with, in terms of the new probationary requirements or the non-probationary requirements, I would ask the court no probation. My client does have the money to pay all fines, costs, fees today. So I guess I would just ask the court to take into consideration Ms. Mason's lack of criminal history, the fact that this is a true first, the fact that it was fairly low in terms of the PBT. And then also my client is on unemployment right now, so she has applied for a few jobs. But I know Ms. Mason from the community, she is a hard worker, she's always kept good employment. So I guess I would just ask the court to take that all into consideration when making the ruling today. Thank you.
Thank you. Anything you wish to state?
Yes, I would.
Go ahead.
I made a huge mistake. I'm going through a divorce and I have two girls at home and I set a really bad example. Was a terrible mistake. So I've definitely learned my lesson. I'm not gonna be drinking and driving ever again.
Okay,
I'm
thank you.
yeah.
That,
Not a good choice.
I believe you when you say that. We always make poor choices when alcohol is involved. That's the nature of it. It's almost like you got to promise yourself ahead of time, if you're going to drink, that you're not going to drive, period. No matter how much or how little you drink, it's just not a good idea ever. I always tell everybody every 50 minutes someone is killed in a drinking and driving related accident in this country, and oftentimes it's the innocent third party that has nothing to do with it. Most people already know how dangerous it is. You're essentially piloting a rocket ship with no ability to steer it, and you're heading toward a surface.
Right, I am very grateful I did not hurt anybody or get into an accident or hit any innocent people.
All right. Well, I'm happy about that too, but it doesn't mean it couldn't have happened. And it'll be the sentence and judgment of the court. You pay fines and costs of $1,500. There's $250 PA cost for the prosecution cost, $50 blood draw fee for the hospital, and $100 police fee. There's $125 in justice fees, and the alternative, and 1 day in jail with credit for 1 day served, and in the alternative 63 days. You can take care of that today before you leave. The staff will type up the paperwork. Also, you'll be ordered to participate in alcohol highway safety education program, which is just, that probably will be arranged online, and the staff will help you do that. Anything further?
No, you got it, thank you.
Okay, can I give you the file to take in to have Mary prepare the paperwork?
Yes, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Thank you. Is, Mr. Klagstad, are you available?
I am, Judge.
Okay, thank you. We'll call the matter then of People versus John Herman Ron III. This is file number 2105077. This matter is set for pretrial today. Any resolution of the matter, gentlemen?
Your Honor, I've spoken with Mr. Flagstad about a week ago, and I see that he's filed an appearance on the case. The people will agree to a delay of sentence for a plea of guilty on count 1. I'm not sure if that's going to be accepted by the defense, but I guess that's up to them.
Do you know, Mr. Klagstad, at this point, it sounds like this is the first enunciation of the plea agreement, or have you had discussions?
We had what I'm going to call preliminary discussions a week ago.
Okay. Do you know, Mr. Klagstad, if the defendant is going to accept that plea offer?
Judge, there's one tertiary issue I'd like to track down. It's an attractive plea offer. I think we're most likely going to get it resolved. But if I could just have a week or two, Judge, there are some secondary concerns from my clients that I'd like to be able to give an answer on.
All right. Are you requesting, maybe it would be a good idea as well to adjourn the pretrial for 2 weeks so that you can have an opportunity to explore any issues that are pertinent to resolution, and then if there's a resolution, we can do it on that date?
May it please the court? Yes, Judge.
That works for me as well, Your Honor.
All right. And Mr. Ron, you're okay with that, just coming back in a couple weeks? Okay. All right, great. You're still at 403 Ackley Road, Is it Manistee? Or Germfast, okay. We'll make sure that's properly stated in the system so that you get your mail, okay? Anything further at this time we can accomplish, gentlemen?
No, thank you, Your Honor.
Okay, thank you, everyone.
Have a nice day.
Thank you. Yeah, you too. Ms. Denholm, do you have a matter?
Yes, Your Honor, the Mercer matter has been resolved.
Okay. Next matter is People versus Thomas Joseph Mercier, file 2106093. This matter is before the court for pretrial, but is there a resolution of the matter?
Your Honor, the people are offering for a plea of guilty to charge a sentencing under 7694A, domestic violence. And people have also, according to my staff, spoken with victim, are agreeing to lift the no contact at this time.
Thank you, sir. Please state your full name, sir.
Thomas Joseph Mercier.
Is your mailing address still 1845 Wawashnosh Drive, Manistee?
Yes.
What is your date of birth, sir?
12/28/68.
Thank you. Did you receive the advice of rights form?
Yes, sir.
Did you read and understand all of the rights listed on that form?
Yes, sir.
And did you sign and date the form?
Yes, sir.
Do you understand by accepting the plea agreement and pleading guilty, you'll be giving up all the rights listed on the advice of rights form and there will not be a trial of any kind?
Yes, sir.
And do you understand the plea agreement that in exchange for a plea of guilty to domestic violence, the people would recommend disposition under section 769.4A of the statute, which allows a delay of type of sentence while you're on probation? You
Yes,
understand that plea
Yes,
agreement?
sir.
On behalf of your client, Ms. Denholm, what plea does he wish to offer to domestic violence pursuant to the plea agreement?
Pursuant to the plea agreement, defendant offers a plea of guilty.
Is that guilty plea entered with your consent, Mr. Mercier?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in exchange to get you to plead guilty?
No, sir.
Has anyone threatened or forced you to get you to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily and of your own choice?
Yes, I am.
Is Alicia Marie Mercier your spouse?
Yes, sir.
And was she your spouse on June 5th when this happened?
Yes, sir.
Were you both in Hiawatha Township, Schoolcraft County, Michigan?
Yes, sir.
Was this at your home at the address you've stated earlier?
Yes.
And did you get in an argument with her over anything?
Yes, I did.
And did that escalate into something more than just verbal argument?
No physical contact, sir.
Well, what did you do to assault her then?
I didn't. It was interaction between her and the slider and me on the other side of the slider door. And she slipped on the carpet because the carpet is at a slant.
So what did you do to assault her?
And you were both pulling the doors.
Well, she was pulling and I was pushing the door at the same time.
So she was trying to close it and you were trying
She was trying to open it.
She was trying to open it and you were trying to close it.
Yes.
All right. So during the time her hands were in contact with the door
Yes, sir, on the outside.
and your hands were in contact with the door on the inside?
Yes, sir.
And she wanted to come in through the door and you wanted to keep her out from coming in
Yes, sir.
the door. And as a result of you pushing on the door, apparently something happened that made her slip and fall.
Yes, sir.
And were you angry when this happened?
No,
Was she angry?
she was, yeah. I was very calm, sir. I'm the one that had called the police for the assistance at the time. So after they arrived in their determination, they felt it was necessary for me to be removed from the premises.
Do you have any other questions or are you satisfied with the record?
At a minimal threshold, Your Honor, I believe that the plea satisfies. Obviously, I think when you infer that there was an argument going on and the door was being used and being pushed both ways, obviously there was hearings on this, there'd be other statements, but I think at a very minimal threshold, the threshold's met for the charge, for at least for assault and or assault matter.
Are you satisfied with the record or do you have further voir dire?
So rely on the record as presented to the court.
All right. Well, the court finds from your statements that your guilty plea was knowingly, voluntarily, and understandably made, that there is an accurate factual basis for a finding of guilty because on the date and location, Alicia Marie Mercer was your spouse, that you were at your home in Hiawatha Township of Schoolcraft County, Michigan, that you engaged in an argument, calm or not, that resulted in something that was closely connected to Alicia Mercer, that being the door, and that you slid the door in a manner that caused her to fall. That's the inference the court makes from the circumstances. And therefore, the court believes that it's satisfied with the factual basis for the record. Therefore, a judgment of guilty will be rendered subject to being set aside under MCL 769.4A. Anything further on behalf of your client, Ms. Denholm?
Your Honor, this is a marriage of not exceptional length, and the parties have been actually married for about 2 years. I think that they have a relationship that's salvageable and that both of them would like to continue. And I understand that Alicia Mercer is willing to continue with the relationship and wants the no contact order to be lifted. Mr. Mercer feels the same way. I think the court can be confident given the circumstances and the relatively low level of interaction here that the 769.48 resolution.
Right, thank you. Anything further by the people?
Your Honor, based on my staff's conversations with victim, I believe that the 7694A is appropriate in this situation. It's really more just an argument that perhaps went further than it should have, and I'm fairly confident that this won't happen again, but I think a short delay to make sure that the parties are on stable ground again, if they're going to reunite, would be a reasonable way to end this case. Thank you.
Okay, thank you. Did you serve any jail time, Mr. Mercer?
Yes, sir.
How many days?
It was just overnighter, so
Okay.
it was that evening, and then they let me out the next
Morning?
morning.
Okay. Anything else you would like to state before I pronounce sentence? All right. I know that there are different degrees of domestic violence. It always starts verbally, which can be power and control issue. But it always seems to escalate into something more, and pretty soon somebody's falling down or getting hurt. So we have to always ask ourselves, what's the right thing to do at this point? And usually it's just to leave the situation altogether and pick up where you left off later, rather than engage in any type of violence. Because when there's a disagreement and there's any kind of physical nature to it, all that does is promote more animosity and makes the situation worse. So it'll be the sentence and judgment of the court be placed on probation for 12 months. If you're doing well after 6, we'll discharge you early. During the probation, this is under MCL 769.4A of the Michigan compile laws, so that if you complete the probation, the charge will be dismissed and there will not be a conviction on your record. Fines and costs are set at $250. State justice fees of $125 and a $35 a month probation oversight fee. Court will assess 93 days in jail, 1 immediately with credit for 1, and 92 are suspended. On condition you complete the probation successfully, I'll give you 6 months to pay the fines, costs, and fees. No use of intoxicants or illicit controlled substances or marijuana. You are subject to PBT and drug testing at any time. You are subject to a search at any time, and you shall display no assaultive, threatening, or intimidating behavior toward anyone. I'm not saying that you did, I'm just saying you can't do it in the future, okay? Any questions? All right. You'll be making an appointment with the probation department, or if we have your phone number and we can get it, we can call you with when to come in to get the paperwork. Okay. Did you post any bond money? Or were you out on personal recognizance? Okay. All right. Thank you. You're free to go. Thank you. Next matter is People versus Nathan William Dillon, file number 2005069.
In the last matter, did you need to state something on the record about the no contact order being lifted?
I didn't need to because I didn't order it.
Okay.
So the bond is over and now he's a sentenced defendant, so there is not a prohibition of contact.
Mike for Dylan.
Oh, yes, we have a non-public matter that we'll be discussing next, so we'll go into audio silence. The video will be up, but you won't be able to hear, and that's the main thing. So because the record is non-public, we'll be proceeding to mute at this time. Okay.
Is this the last matter of the day?
We have one more, Mr. Goodrow, that is set for 10. Is he here?
I've not seen him.
I have not. If you want to just give me 1 second. I
All right.
will pause the live.
We'll handle, if he's, there is a pretrial in Clifford, People versus Clifford Goodrow, we'll dispense with first.
I'll see if he's out there.
Okay. And Ms. Denholm is listed as attorney of record on him.
Ms. Denham says he hasn't showed yet.
Okay, that's